Welcome back to the channel. Today, we step into a case that's more than just a landlord versus tenant dispute. It's a collision of legal deadlines, financial struggles, and credibility in front of a no-nonsense judge. This is the story of Riverside Tow Houses versus Katherine Yoder, a case that began with a relatively modest rent dispute and spiraled into a full-blown eviction battle. On one side, we have a property management company and their legal team, armed with detailed payment ledgers, court dates, and procedural rules. On the other, a tenant who claims that unemployment, mental health struggles, and maintenance issues make her situation exceptional and deserving of another chance. But the judge isn't just deciding on unpaid rent. They're weighing procedural rules, deadlines, and whether Ms. Yoder's claims rise to the level of a legal defense. This case will pull us through missed court appearances, bounce checks, and even allegations about unsafe living conditions. Stick with me as we break down the timeline, the arguments, and the turning points that ultimately sealed Ms. Yoder's fate. Because when you miss deadlines in court, it's not just about the facts anymore. It's about whether the law will still let you fight.
September, she's now alleged to be $1,800 in arrears. So she was personally served with a complaint, and we had a hearing on November 15th. Let me look at the signed copy. The defendant, here it is.
Right here is where the procedural clock really starts ticking. Ms. Yoder was personally served with a complaint, and that's huge in landlord-tenant cases. Personal service means there's no ambiguity about whether she knew about the case. From this point on, the law expects her to respond, show up to court, or take other formal action. And in eviction law, I didn't know won't fly when the court can prove you were served. This is the first major warning sign in the case, a tenant who's been properly notified, but who won't appear at a critical hearing.
But anyway, it wasn't a formal pleading, it was an email. So it doesn't have anybody's heading on it. She didn't pay a filing fee. She simply said an email, didn't give service to the plaintiff, and said, I respectfully request that the default judgment entered against me be set aside. I was unable to make rent payments for the month in question because I was not working during that month due to challenges. I live in an income-based apartment and technically should not have been required to pay rent during those months. As I indicated, we just resolved another case to the same tenancy in August. I understand the importance of meeting financial obligations and other important meetings such as the scheduled court dates that I failed to attend. I did not attend to avoid my responsibilities. Fortunately, due to my mental health challenge, I was unable to respond to the lawsuit in a timely manner. I asked for the opportunity to present my case fully and discuss a fair resolution, including the possibility of payment arrangements. I am committed to resolving this matter and sincerely request the court's consideration to set aside the default judgment. So we treated it, even though it was just an email, without notice to the other party, and I said that
This is a pivotal moment. Ms. Yoder sends an email, not a formal motion. In legal terms, that's like bringing a handwritten note to a boxing match. There's no filing fee, no proper service to the other party, no affidavit of a meritorious defense, all required under court rules. Judges may occasionally show flexibility, but skipping these procedural steps is risky. And while she cites unemployment and mental health struggles, the law still requires proof, not just statements. This was her shot to get the default judgment overturned, but the approach left her vulnerable.
I'm not sure that rises to a legitimate reason for failing to appear, and a meritorious defense. Her rent should not have been set in this amount. As I indicated, we just dismissed the other case in mid-August. She had apparently paid some rent because the claim was for more than what the judgment actually entered. So we asked the Cox Law Firm to be here. We forwarded a copy of the defendant's email to them, and Attorney Carrie Zanin is here. Ms. Zanin, what's the plaintiff's position?
Well, Judge, I was going to argue the court rule. I don't believe that good cause was, well, first, I don't think we even need to get to the good cause and the meritorious defense, as this motion should have been filed within 10 days, and motion, email, that was we took the judgment was signed on the 15th. 10 days would have been the 25th. She's an additional 9 days beyond that date. I don't believe she's, in compliance with the court rules as to the time frame, and I don't believe she's delineated good cause to set aside. She was personally served. She had the court date. She didn't appear, and I don't believe there's a meritorious defense either. As to your questions about the August, I can tell you by looking at the ledger, she did make a payment late in August that brought her balance down to $70, and that's probably why the dismissal. And then, of course, September, October, November, and December are now due. So I would ask that you deny the motion.
Here, the landlord's attorney does something critical. They bring in ledger evidence. This isn't just an opinion. It's a written financial record showing when payments were made and when they weren't. By pointing out that payments dropped to nearly zero after August, they're building a rock-solid argument that the default judgment was justified. It's not emotional. It's numbers on paper. And in court, especially in eviction cases, numbers tend to speak louder than explanations.
Payment that shows is the utility reimbursement, so I apologize. But what I'm showing at this point with December is that she owes $923. So an extra $20, Judge, on the judgment.
All right. Now, sometimes there are a couple things. When you fail to appear in a landlord-tenant case, you have 10 days to appeal. And you didn't file anything within 10 days. You filed it on December 4th, which is 19 days after the judgment entered. Now, theoretically, on a motion to set aside default, you have 21 days to move to set the default aside, but that's in a money judgment. This was a landlord-tenant judgment for possession. So there are multiple issues. One, there's no meritorious, well, it's multiple. You didn't properly file it. It was filed more than 10 days after the appeal period. It wasn't served on the other party. We served it. You didn't file an affidavit of meritorious defense, and I'm not sure there is a meritorious defense. You simply owe the rent. Somehow it's your contention that it shouldn't have been calculated as this, but we just had another case about 3 weeks before it, and you're employed now and working somewhere in what looks like a good job. The
judge's breakdown here is a masterclass in procedural law. For possession cases, tenants usually have 10 days to appeal after a default judgment. Ms. Yoder filed 19 days after the judgment, nearly double the allowed time. Even if the court treats it like a money judgment, there's a separate 21-day window, and she still didn't meet the other requirements. In other words, her request wasn't just late, it was missing multiple legal ingredients. This is where we see the law's unforgiving side. Deadlines in court aren't suggestions.
I've been unemployed
well, you said
since
you were
July.
out of state at a conference.
That is not related to work, Your Honor.
Oh, okay. I thought it was.
And I've been unemployed since July 25th. And the reason why I've not, she's giving me the $528 rent fee for August is because I neglected to let her know that I quit my job at Gemstone Solid Surfacing in Elkhart, Indiana, July 25th. So she's putting that $528 for rent in August, and then the extra fees are the court fees for the missed court hearings that I missed. So how am I supposed to pay for that with no job? Plus, I've had interviews. I've applied for over 30 jobs remotely and out of in the workforce, and I've not been able to get hired. For that reason, I really don't know, other than the fact that I've been trying to do my best.
Well, I respect that, but none of that's a defense of the fact that you haven't paid your rent. Now, Ms. Kalmbach, could you unmute? She says she quit her job. Did she ever notify management or ask for a recertification?
She did, and that's why she owes the August rent, because she did come in and we did take her down to zero.
All right, so she owes August rent, but not, she's zero currently.
Yes, September 1st, she went down to 0 rent.
All right, so how do we get 923?
Let me look at her ledger. She had some non-sufficient funds because she wrote us a check on a closed bank account.
Well, she had told us a couple.
This moment might have sealed the case. Ms. Yoder brought in a check for $658, but the account it came from was closed. In many states, that's not just a failed payment. It can be a misdemeanor offense. The judge even delayed the hearing to see if the check would clear, giving her a second chance. But when it bounced, it didn't just hurt her credibility. It confirmed the landlord's narrative that payment wasn't reliable. In a courtroom, a bounced check is like waving a red flag in front of a judge.
I'm sure it would have clear. The arrearage was $658, and that was through November, and it was $184.47. So it didn't include, she brought in a $658 check, but did not include legal fees. So she missed the first hearing on November 4th, but because the check had come, I waited to see if it cleared. I continued it to November 15th. Ms. Kalbach indicated that the check had bounced and did not clear. The defendant did not appear, and I issued the default judgment. 718, 184.47, and 902.47 total. The check came back as account closed, which actually is a misdemeanor. And so the check didn't clear, the account was closed, the defendant didn't appear, she didn't file anything within 10 days, and the plaintiff still wants her to move out. All right. So,
Your Honor, could I add something else?
yes.
Back in July or August, I believe, the landlord came in to check my ceilings, and she had said that she was going to come get them fixed. And when you look at my ceilings, I can provide photo evidence as well if you need that. It's bowing down. And there's been 2 other tenants that I know of personally whose ceilings have caved in and fell.
Stop. The time to raise that defense was at the time of the hearing. We were all here. Now you haven't paid the rent. You didn't file it at a timely manner. You didn't.
Here, Ms. Yoder brings up a completely different angle: ceiling damage and safety concerns. In some cases, habitability issues can be a strong legal defense against paying rent. But timing is everything. She raised it months after the alleged problems began and after multiple court dates had already passed. The judge cuts her off because this defense should have been raised at the original hearings. In legal terms, this is called waiving a defense by not asserting it when you had the chance.
Kalmbach or Ms. Cox, do you have any interest in allowing her an opportunity to pay the unpaid rent or simply ask for a writ of eviction?
I think at this time, Judge, we're asking for the writ of eviction.
I don't believe I've received it yet. Let me look.
I would rather pay the $528, meet you in the middle with that. I'm going to have to get some help, but I would be glad to do that because I don't have anywhere to move to right now.
Yeah, I do have the writ of. They don't want you to do that. I did get the writ of restitution eviction on December 9th. The motion to set aside the default is denied. It's outside of the 10-day appeal period. Even if it was considered that it was filed within 28 days, there's no good cause shown for failure to appear, and there's no affidavit of meritorious defense. They don't want you as a tenant anymore, and it's going to show as an eviction on your record, which may make it very hard for you to get into any other subsidized complex. They don't, theoretically, this order will allow them to evict you tomorrow or Monday morning, but maybe they can work out some sort of accommodation or agreement. But I will sign the writ of eviction. So you're in a difficult spot. It's right before Christmas. You had two opportunities to be here. You did not appear. You presented a check for payment, which was on a closed account, so the payment wasn't made. And to further put salt in the wound.
And that brings us to the end of Riverside Tow Houses versus Katherine Yoder. In the end, the motion to set aside the default judgment was denied, not just because of unpaid rent, but because it missed critical deadlines, lacked proper legal form, and failed to prove a meritorious defense. The judge authorized a writ of eviction, which could be enforced immediately, right before the holidays. This case is a cautionary tale about how in landlord-tenant disputes, procedure is just as important as the facts. You can have sympathetic circumstances, unemployment, mental health struggles, even property damage, but if you miss the legal deadlines or fail to present your case properly, the court may never even consider your arguments. So, what do you think? Should the court have given Ms. Yoder another chance, or was the landlord justified in pushing forward with eviction? Let us know in the comments below. And if you found this breakdown as eye-opening as we did, hit that like button, share this video with a friend, and don't forget to subscribe for more real courtroom stories and analysis.